Good morning, everyone, and thank you very much for joining us, both those people in the room and those people joining online. My name is Jean-Pierre Gauchi. I'm a senior fellow here at BICL, and it is my great pleasure to welcome you all and then to introduce our wonderful panel this morning, talking about individual reparations for human rights violations in Ukraine. Just by way of logistics, for people in the room, many of you will know this already, but if you are speaking, asking a question, etc., it is very important that you use a microphone so that the people online can hear you, and Iris has kindly agreed to chaperone the mic around. That is even more important because one of the discussants this morning is joining us online, and therefore she will need to hear, obviously, the questions that are being asked. If anyone asks a question that doesn't get through a mic, we will try to repeat the question as much as possible. The second thing is, as far as we're aware, there's no fire drill planned today. So if you do hear a fire alarm, that is something that you should heed to, and the meeting spot is outside by the park. Okay, so my role today is very, very limited, and it is only to introduce the speakers at the start, and then I will let the conversation flow. So the speakers this morning will include two fellows here at the Institute, Katerina and Roman, as well as two discussants, Felix and Mariana. I'll run through their profiles very quickly and then hand over to Roman, who will be the first speaker. Just by way of how things will run, Roman and Katerina will give their presentations at the start, and then Felix and Mariana will respond to those presentations, and then we hope to have an open and frank conversation with everyone in the room and online. The event is being recorded, so please do, so just so that people are aware, if anyone has any objections, please do let us know. Starting with the speakers, the first speaker will be Professor Roman Petrov, who is Jean Monnet Chair in EU Law at the National University of Kyiv at the Mola Academy since 2010. He is the head of the Jean Monnet Center of Excellence in EU Studies at the National University of Kyiv and director of the German Law Institute at the same university. Roman obtained his PhD at Queen Mary University of London under the supervision of Marie Scramona. The Maltese connection is always there. And he has conducted research at the European University Institute, the University of Heidelberg, the Uppsala University, Ghent University, University of Oxford, again at Ghent, etc. He has also written the first Ukrainian textbook on EU law, and his key areas of research and teaching are EU law, EU external relations law, and harmonization of legislation of third countries with the EU acquis. The second speaker is Dr. Katerina Busol, who is a Ukrainian lawyer specializing in international humanitarian, criminal law, transnational justice, as well as gender and cultural heritage. She is a senior lecturer at the National University of Kyiv. She has worked on various justice issues and has expertise and specific focus on the conflict between Russia and Ukraine. She has published extensively on cultural heritage, conflict-related sexual violence, reparations and achievements, and avenues of Ukraine's transitional justice process, and has recently worked as a practitioner with the Clooney Foundation for Justice, UN Women, Global Survivors Fund, as well as Global Rights Compliance. Our discussants are Dr. Felix Torres, who is assistant professor at Birmingham Law School. Felix is completed his PhD studies at the University of Nottingham. Another connection to BICL is that one of his supervisors is a former director of the Institute, and his main research and focus is on state responsibility and issues of reparations in post-conflict societies. His work has been published in leading peer-reviewed journals in the UK, Europe, and South America, including the European Journal of International Law and the Revista de Estudios Sociales. Our next speaker is Mariana Gott, who is the head of guide at the Global Survivors Fund. She's a human rights practitioner with over 20 years experience in post-conflict justice, including at the Rwanda Tribunal and the Special Court for Sierra Leone, where she was a legal advisor. More recently, she was head of program at the AG Trust and deputy director of redress, where she has been been its post-conflict justice advisor, working on transitional justice cases and projects which affected communities in the Congo, Northern Uganda, Kenya, and Central African Republic. With that being said, I will hand over to Roman and I will stop talking.
Thank you very much. Yeah, thank you. It's great to be here. And on the first slide, you can see a beautiful campus of my home university in Kyiv, Maya and Katerina's. It's a National University of Kyiv Mogila Academy, which is located in a very beautiful downtown part of Kyiv. So once the war is over, welcome and come and visit it. The purpose, and I hope that Jean-Pierre will keep his eye on a timeline and will warn in advance. So we've been allocated 20 minutes to talk. So my objective of my first intervention actually is to lay floor to Katerina to actually delve into the subject matter. I will briefly describe the status quo situation, which is related to the war, with a particular emphasis to the so-called phenomenon of non-recognized entities, which is a very important part of the warfare in Ukraine. And of course, issues related to the reparations. So you can see there is a brief plan of my talk, but of course we will focus more on issues, and you are free to ask any questions when you wish. There is a map. There is a map of Ukraine with the colors of the eastern parts of actually where I come from the area of Donbas. Before we discuss this topic of reparations and the warfare, it's very important to understand that from Ukrainian point of view, the war in Ukraine can consist of several stages, several parts. So when we talk about the invasion of Ukraine, which took place on February 24th, 2022, it's only probably the latest and one of the parts of the war, ongoing war in Ukraine. Basically, when we talk about war in Ukraine, we start from March 2014. It's when autonomous part of Ukraine, a Republic of Crimea, was annexed by the Russian Federation. The procedure took place of the annexation very quick and swift. Basically, the Republic was, as President of Russia pretended, was captured and controlled by local militia, who in fact were Russian army dressed in uniform without insignia. So they pretended to be local militia, but in fact, they were parts, all the units belonged to the Russian army. And in the course of this annexation, when all major infrastructure and state buildings were captured and controlled, then the Republic of Crimea announced its independence. It lasted just a few weeks because hastily assembled referendum took place. And basically on March 18th, Republic of Crimea was integrated into the Russian Federation. So it was the first stage, first part of the war, which can focus on the Autonomous Republic of Crimea. Of course, the international community didn't recognize the legality of this act. It was considered as a blatant violation of international law and sovereignty of Ukraine. And the Russian Federation itself claimed that it was a lawfully organized procedure of self-determination via all people's referendum. However, the very first cases of violation of property rights of Ukrainian nationals took place actually on the territory of Crimea. The second stage of the warfare happened exactly in the east of Ukraine. You see this dark color. These are two most industrial regions of Ukraine, Donetsk and Lugansk, and these regions were actually not openly, they were not annexed in the same way as the Crimean Peninsula was. They came through the stage of announcing itself as as independent states, but in fact, according to international public law, these areas were treated as non-recognized entities. Nevertheless, these entities had their own legal system, own citizenship, own borders, and so they pretended to qualify and to apply the requirements of being sort of independent entities. Right now, these regions became already part of the Russian Federation through the decision of the president of Russia, who integrated these regions in September 2022 into the Russian Federation with a special status. They still keep the status of republics. And the third stage of the warfare actually relates to the invasion. Invasion, as you all well know, took place on February 24th, 2022. Initially, more than 20% of the Ukrainian territory was occupied, including quite significant part of the Kyiv region, Kharkiv, and so on. And as it stands today, the Russian Federation controls 18% of the Ukrainian territory. For me, it's difficult to compare and to judge, but I guess it's like 20%, probably possibly Scotland could constitute 20% of the Great Britain territory, yeah? And there was a comparison with regard to Germany. So the area being occupied by the Russian Federation is equivalent to Baden-Württemberg and Bayern in Germany. So for you just to understand the scale, it's quite a lot, it's quite a lot. But what complicates the matter further, that Russian president announced an incorporated territory of Ukraine, which the Russian Federation doesn't control. So, for example, you can see the southern part of the river Dnieper, and this southern part of the river Dnieper goes via two regions, Zaporizhia and Kherson. And what the Russian parliament and Russian president did, they incorporated the entire regions into the Russian Federation without having control over this territory. So now we are facing very unique from point of view of international law situation when a neighbor country annexed by military means and by legal means significant part of the Ukrainian territory, which it does not control. And of course, in opinion of experts and scholars, it complicates a future peace deal very much, because any issue of a peace deal would eventually require a change into Russian constitution, denouncing their sovereign rights over these territories. But for some reason, Putin hastily accelerated this process and incorporated these territories. Furthermore, so it's about the territory. So we are having 3 layers of territory being annexed by the Russian Federation. And also it's very important to mention status of nationals who live on these territories. It's also quite complicated, because before the first stage of the war, before 2014, of course, all people residing on the occupied territories were Ukrainian nationals. Then once the Crimean Peninsula got occupied and the area of Donbas, these people, residents and nationals of Ukraine, had to change, most of them, their nationality and residual status. Basically, the most interesting transformation took place exactly in the eastern regions of Ukraine, where Ukrainian nationals first, in order to survive, in order to get minimum social protection, they first had to apply and get so-called local passports, local citizenship of non-recognized entities of Donetsk and Lugansk People's Republics. And in addition, on top of it, they got a possibility, and then they were actually encouraged to do so, to take the Russian citizenship. So basically, as it stands today, people who reside in the eastern part of Ukraine, many, not all of them, of course, but many of them are in possession of at least two citizenships. well, most of them, because already citizenship of Donetsk and Lugansk republics is not in place anymore since these areas were incorporated into the Russian Federation. So these people have two citizenships. Somehow they even can get more, but it also complicates very much their legal status, their right for reparations and recovery of their property, and as well legal mechanisms of protection of their human rights. We are going to talk about it later on. So this is a brief overview of the all complications and legal status of the territory and nationals who live and reside on these areas. Just a brief introduction and as related to the east of Ukraine. This is a picture of Donetsk, how it looked like before the war, before 2014. It's my native city, and now of course it doesn't look the same way anymore. It's a center of a very hard and horrific warfare. So basically what happens that before the first stage of the war, it was one of the political, cultural, and industrial centers of Ukraine. It was considered informally the second capital with a very strong political power, which produced one president, 5 prime ministers, and a very strong opposition party. And also most mighty Ukrainian oligarchs were based there and actually influenced very much Ukrainian politics and business. And just in the course of few weeks, from being the second richest and most influential Ukrainian city, this city plunged into a separatism, and non-recognized entity was established. To explain in a brief terms, in my opinion, it was a perfectly and skillfully organized special operation, intelligence operation by the Russian Federation, when in course of few weeks, groups of unidentified Russian nationals crossed the border. As you have seen on the map, Donetsk and Lugansk regions, they share a common border with the Russian Federation, and started civil unrest, rallies, demonstrations, which was then joined by supportive local people. And in the course just of 1 week, these groups of people stormed the local parliament, stormed the local police, got possession of arms, and announced, just on a square, announced and elected new people's governor, a person from a crowd who apparently appeared to be my former student from a faculty of history. And then stormed the parliament and announced a new republic and proclaimed declaration of sovereignty. So it was very smooth, very quickly organized. It was very local, so people actually were not aware of what was going on. And once getting a hand at some weapons at the police office, they basically started getting control over main infrastructural objects. And a referendum was announced and took place on May 11th, 2014 in Lugansk and Donetsk to announce these independent republics. From the Ukrainian point of view, the Ukrainian government lost control over these two cities already in May 2014. And in order to qualify and deal with the situation, the Ukrainian government announced so-called anti-terror operation. So it was not war, it was not any sort of military occupation, but it was anti-terror operation with the purpose to restore governmental control over these territories. On the picture, you can see one of the infamous leaders of this movement, a Russian national, former military intelligence officer, Igor Girkin, Strelkov is his second name, and who actually came from Russia and set up first units who got possession of arms and started control over certain territories. And he was later appointed as a Minister of Defense of the Donetsk People's Republic. So his example is quite important to illustrate that first and activists of this movement, they actually came from the Russian side and they were Russian nationals. On these slides, you can see this posters which came before, which were displayed before the referendums in Crimea. So you can see how local Ukrainian nationals were sort of encouraged to vote in a correct way. So it also constitutes a part of hybrid warfare via propaganda and misinformation of nationals living there. So it's this poster was displayed just before the referendum in Crimea, and you can see clearly the message. It's difficult to be mistaken. It's in Russian, but it says we choose either or, and it's your right what you choose. So it's clear what you choose from this poster. And this is poster on the eve of the referenda in Donetsk. It also with the same message: make your choice, and it shows by either Ukrainian choice or so-called independence. And it's also just exemplary how misinformation and propaganda played a crucial role in this case. There are some legal issues related to these non-recognized entities. These two republics were not recognized. Actually, their final recognition by the Russian Federation was a direct prerequisite for the invasion. By the way, the invasion itself, which took place in February 2024, was publicly justified by President Putin. There was a TV address. I remember I woke up at 5 because of noise. It appeared to be missiles coming down in the residential area. I switched on, of course, to understand what's going on the internet. And there was a address by Putin, and he explained the reason of the invasion. He said it was not invasion, but it was preventive military operation by the Russian Federation to prevent forthcoming Ukrainian invasion. And he justified the invasion on two articles of the UN Charter, Article 1 and Article 51, right of self-determination and right to use force to protect itself. Actually, main prerequisite of his so-called military operation was to defend and protect rights of Russian speakers, Russian nationals, on the territory of Donetsk and Lugansk People's Republics. So these two areas, they play a crucial role for understanding at least formal legal justification of the invasion. So what in practice happened? Ukrainian nationals were forced and encouraged to take Russian citizenship. And once they did so, already the Russian Federation assumed itself in a right to defend their rights, as it was claimed from Ukrainian genocide by military means, based on the UN Charter. So it was, of course, for any international law lawyer, quite absurd logic to follow, but how it was explained. Briefly, these two republics, they were not recognized. Were only very late, just before the invasion, people living on the territory of these republics, they possessed several citizenships. Ukrainian qualification of these territories was temporarily occupied territories, and it led to understanding that Ukraine keeps legal formal control over these territories, but temporarily cannot exercise full governmental control. And therefore, the Ukrainian government issued special law introducing a status of so-called displaced people. So the Ukrainian nationals live willing to enjoy full social support and full scope of rights under Ukrainian legislation, were asked to leave the territory of the temporarily occupied territories, to move on the mainland Ukraine, get the formal status of a displaced people, which was formally specified, and to seek governmental support, material and financial, to establish themselves in this capacity of displaced people. So it was a scheme, it was a track introduced by the Ukrainian government. However, it didn't prevent from and didn't help to avoid so many complications related to human rights. From the EU point of view, an international community and the EU had also to somehow qualify the status of these territories from point of view of international law and their treatment. So, for example, the European Union treated these two non-recognized territories as, I quote, non-government controlled areas of Eastern Ukraine. It's a brilliant phrase and scope which comes from official EU documents and which actually tells a lot. So it basically emphasizes that these areas are just of Eastern Ukraine, so it's part of the territory of Ukraine, and it's a non-governmental control. So once the Ukrainian government assumes full control over these territories, it should be considered as an inherent part of Ukraine. Furthermore, I'm as an EU lawyer feel obliged to mention it. As you might know, the very first phase of the war led for Ukrainian side to conclude the EU-Ukraine Association Agreement, which is a very important part of our legal framework of cooperation with the European Union. And this agreement provided quite a few and important rights and privileges for Ukrainian nationals and Ukrainian companies. So the agreement was negotiated in 2012 before the war, but it entered into force in 2017, basically. And partially it was in action in 2014. So there was a question how to apply this global framework agreement vis-a-vis Ukraine, and especially vis-a-vis territories which Ukraine doesn't control anymore. And it was a very interesting legal sort of exercise. So basically, it could be argued that the agreement, territorial application of the agreement, covered the whole territory of Ukraine. Even, I'll just maybe go back to the map, but yeah, for you to, yes. So it covered the whole territory of Ukraine, which even was not under full governmental control. You may ask how and how it worked. So when we talk about Ukrainian nationals, so once Ukrainian nationals managed to keep their Ukrainian passports, they could, once they cross the front line of the non-recognized entity, they could travel free, they could enjoy visa-free regime within the EU, and they could enjoy privileged treatment within the EU territory. With exception to the UK, even before the Brexit, because of special, yeah, we all remember this old good times, yeah. But nevertheless, it was quite significant encouragement. It was the very first time when Ukrainian nationals realized, being on these non-controlled areas, that it's actually a very good move to keep the Ukrainian passport. Because already at that time, the Ukrainian passport provided Ukrainian nationals more rights and privileges than the Russian passport. And then in response, Russian authorities asked everyone who wanted to apply for Russian passports to give up Ukrainian. So they already realized that it's very important to encourage people to get from the Ukrainian passport. So there was a sort of campaign of passportization or passport war when both sides tried to take people on their side. Now it came to the pinnacle of this passport war. Unfortunately, it took place last few months ago, if I'm not mistaken. The recent edict of Russia, President of Russia, Putin, was that look at the southern areas, recently occupied areas of Ukraine. So the edict was that everyone among Ukrainian nationals not willing to apply and get the Russian citizenship and to give up the Ukrainian passport could be deported from their place of residence on the ground of national security. So basically the message is the following. If someone is not willing voluntarily to apply and get the Russian citizenship and to give up the Ukrainian passport, this person, family, is under danger to be deported elsewhere, who knows where, especially and also potentially to lose property rights. But it's another story, of course. And the key criteria for distinguishing whom to deport and when lays in this vague criteria of national security. It could be, for example, following recent state of human rights in the Russian Federation, it could be Facebook or Twitter message criticizing the government, or any sign of support of the Ukrainian government, or just suspicion. So criteria is very vague. So basically anyone who is not willing to get the passport. And it's very important. So it's how it stands now. And of course, it also brings me to a point what Ukraine is going to do and how it's going to deal with the Ukrainian nationals already having Russian passport, which was acquired. Well, if voluntary, it's one case, but if it was given forcefully, it's one case, but if voluntary, and it's very interesting issue to discuss later on. Sir, how many minutes?
Just about over. So.
But I have so much to tell. So I'll just be very brief. I'll focus on just one issue, what I want to mention. Very quick message. I wanted to tell you results of my research when I compared constitutions of the Donetsk and Lugansk People's Republics, which suddenly appeared over sudden in course of 1 week and were adopted by the local parliaments. I compared it, I started searching where this text came from, and it was no surprise. It was a copy-paste exercise from the Russian constitution with subsequent changes. So it's like for those who is doing law transplants, it's a very perfect case to study how it's been done in a time of warfare. You just copy constitution, change, but there were some interesting changes. For example, separatist authorities decided in the text of their constitution get rid of a very classical expected provision on international agreements and standing of international law principles. They just got rid of it for some reason. And as it was later understood, it was done on purpose to provide a legal base for potential show trials over Ukrainian and international prisoners of war. And by the way, President Putin, before the invasion, he mentioned that one of the objectives of the campaign is to set up sort of second Nuremberg, a big show trial over Ukrainian and international prisoners of war. And certain preparations were made already to take place for this trial in the city of Mariupol, which is very interesting. Okay, I stop here. And my last issue, it's about human rights protection. So very briefly, according to the European Convention on Human Rights, the Ukrainian government and famous and known case law, Ilascu, Caesar, and Chlebnik, Ukrainian government, of course, was responsible for providing for application of the convention within all its territory, including non-controlled territory, but conditional on the facts. And as it follows from these cases, Ilascu, Caesar, and Chlebnik, that the Russian Federation was recognized by the court as having full responsibility to compensate any material and non-material damage caused by the occupation of parts of Donetsk and Lugansk regions of Ukraine, in accordance with norms and principles of international law. I think at this point I stop because I don't want to exploit, and I hope we will discuss, we can have a chance to discuss it later on. So please, sir, I give you.
Thank you very much. Thank you very much, Roman. And I'm sure we'll get back to some of the points you didn't go into details of. I don't think Katerina is using slides, so I will take the laptop to make sure that we can monitor questions. And okay, Katerina, do you want to use? Yeah,
it's on it, and I just want to speak.
Yeah, it is.
Because I thought, yeah, okay. Hello, everybody. Thank you very much, and apologies for not using the slides. I somehow thought that it would be more like interactive and reflective, so apologies for the lack of the visual picture. And thanks a lot to Roman for the brilliant introduction. I actually had one structure of my presentation, but now I've made so many notes on the issues that I would want to respond to. My principal presentation will contain from 3 parts. First, I will speak broadly about Ukraine's transitional justice efforts before the full-scale invasion and what portion reparations have had, if not, in those efforts. Second, I will comment on how the survivors, and we don't have much data, but still, how the survivors commented on their needs for reparations and where they were involved in the process of designing them, or whatever reparations measures were in place before the full-scale invasion. And the third part of my presentation will focus on the post full-scale invasion. In particular, I will, of course, comment how the circumstances of the all-out war with Russia should redefine Ukraine's approach to reparations. And I will also specifically touch upon the recommendations of the UN Commission of Inquiry that issued its last report on Ukraine in March this year. And also I will comment on the developments with the registry for damage recently approved by the Council of Europe, and whether that could be an viable avenue for individual reparations for victims of atrocity crimes. So as regards where Ukraine stood with the holistic support to survivors of conflict-related crimes, alleged war crimes, crimes against humanity, and now allegedly genocide before the full-scale invasion. Ukraine has had a big number of different domestic and international justice efforts, essentially since the beginning of the war in 2014, apologies. And the problem both then and after the full-scale invasion was that these measures largely focus on criminal accountability. So they focused essentially on the documentation, investigation, prosecution, and adjudication of these crimes, or the submission of relevant evidence to, for instance, the International Criminal Court, which does have the reparations avenue, as we know. On the one hand, this is something that survivors commented that they did favor, because both the larger Ukrainian public before the full-scale invasion and the immediate victims and witnesses of conflict-related crime would say that justice and accountability, and essentially naming and shaming of Russia, naming that Russia and its agents are the perpetrators, that this is the first priority for them. But on the other hand, of course, such a policy from the government of Ukraine did not meet all the other needs of survivors. And Mariana will comment in more detail on the current work with reparations and with victims. But before the full-scale invasion, we managed to have a small study of the needs of survivors of conflict-related sexual violence. Most of them have been in places of unlawful detention in eastern Ukraine, including in notorious Izolyatsiya, the art center, which has been turned into the detention center and essentially a labor camp. Also a couple of survivors from unlawful detention in eastern Ukraine. And they would say that, yes, justice was their first priority, but of course they would also point out the need in housing, because many of them would have to relocate for security concerns, or because their property had already been expropriated by the so-called authorities of the so-called Donetsk and Lugansk People's Republics. They would also stress the need for sustainable medical and psychological support, and what I found very touching and revelatory, also couple counseling, because many victims of conflict-related sexual violence who participated in our study, they of course reported the issues of reconnecting with their partners, to building new intimate relationships. And it's essentially the guidance which they voiced both for the government and for the civil society to expand the help, the holistic support to such survivors. They would also specifically emphasize the need for additional professional development or training, so that after the relocation they could have broader job opportunities, and the extensive support to the wider family members. They would stress how the period of their absence while they were in detention would also reverberate very heavily with their family members, especially their partners, their parents, and their children. And this is something that Ukraine was not able to do at the moment, because understandably such holistic medical care, such holistic, not just one at a time, but continuous psychological support, let alone the wider support to family members, was not something the country could afford during the first stage of the war, when indeed even the justice measures, we saw very slow response, very slow support. So there was little practical chance that even if Ukraine were willing then as a government to ensure these measures, that the international donors, the international organizations or NGOs were as willing, would have been as willing to help then during the initial phase of the war, as they are willing to help after the full-scale invasion. So at least during the first stage of the Russians' aggression, we did understand the needs of survivors. We did understand that reparations were not prioritized in general and as a part of transitional justice policy. And we also saw that the civil society, in a way, was supporting the position of the government of prioritizing criminal accountability. This was changing slowly in 2019, 2020, and 21. So essentially in the period leading up to the full-scale invasion. Quite interestingly, it was President Zelensky, then newly elected, who said that while accountability is important, it's very necessary to harmonize first different accountability efforts, all these efforts between international courts and in Ukraine's criminal proceedings, but also to expand Ukraine's vision of justice and discuss a potential truth-telling mechanism. And for that, the Institute of the National Remembrance was discussed potentially as the forum for hosting this truth-telling initiative. The institutional reforms were discussed as well, the reform of the judiciary, the setup, the overdue, but still the setup of the different anti-corruption bodies, and more strategic planning for the reintegration, the occupation and reintegration of Crimea. And in this discussion, in this TJ policy making, which was led by a special working group under the Law Reform Commission, finally, the discussion of reparations came up. It wasn't very detailed, but it was important that at least the term appeared. And why I stress it, because in Ukraine's public consciousness, I think it's the thing for the post-Soviet area in general, reparations would usually be understood as something more connected with the interstate compensation after the war, but not the help to individual survivors. Therefore, it was important both for the state and for the civil society to change this mindset and to understand that this is also the remedy for the victims of individual victims of atrocity crimes. The working group that I have mentioned under the Law Reform Commission developed a draft roadmap of transitional justice, which had just the key. It's not public. Some experts, including myself, have had a chance to review it. So I could just say broadly that it incorporates the key principles of TJ, but the idea was that this remains a generic document which would be adopted by a presidential decree, and further on the basis of a presidential decree, the Cabinet of Ministers develops a detailed action plan. And this was considered to be the stage where finally Ukraine will have a more detailed reparations framework. Now, this never happened because of the full-scale invasion, so the roadmap was under the consideration of the president as of February 2022, and the working group following the all-out invasion just announced that they continue their work and that they will submit their recommendations to the presidents how to reshape the roadmap in response to the challenges of the all-out war. Naturally, this hasn't happened, or at least this hasn't been reported so far. And why I say naturally, because again, with the gravity, with the territorial scope, with the new diversity of the crimes that the post-February 2022 events brought, I think it was quite expected that both the international, the government, and the civil society effort was focused on the documentation for the purposes of criminal proceedings. Whereas now, a year later, it seems finally there is a shift, because both the survivors, again, they stress that while they support the proceedings in Ukrainian courts, they also are very now favoring UJ, universal jurisdiction proceedings. They still stress that with such a mass damage or destruction of the housing, it should be the broader support for the victims. It should be the broader reparation framework finally in place. Now, there is an important also point that it's, of course, the first and foremost obligation of Ukraine to ensure as much help to victims and witnesses of atrocity crimes as possible initially, and to then cover that up by hopefully getting the compensation through the repurposed frozen assets from Russia. But Russia, of course, is also under obligation to help these victims. And this is where I would want to allude to Roman's presentation when he spoke about passportization and generally the legislative measures which Russia adopted with respect to Ukraine's occupied territories. At least two of these measures are important. First, passportization as such, because unless people who were not even yet, for instance, direct victims of atrocity crimes, they could retain their property rights and they could maintain any decent livelihood only if they obtained Russia's citizenship, and this would entitle them to also retain the property in the occupied territories. And the second, very interestingly, Russia recently proposed the amendments which essentially allowed not to prosecute activities which would qualify as crimes under Ukrainian or Russian legislation, but which were perpetrated for the interests of Russia or the newly occupied areas. So essentially, Russia allowed itself not to view certain violations perpetrated by itself as violations or as crimes, and it expressly proposed not to allow any remedy for these violations. Now, looking at the recommendations of the UN Commission of Inquiry and the developments with the Register of Damage under the Council of Europe. The UN Commission of Inquiry made two important recommendations which concern reparations. And I would want to stress the composition of the commission, because one of the three members is Pablo de Greve, the first special rapporteur of the UN on transitional justice issues. And the report of the commission has a paragraph saying that while all these justice efforts and criminal accountability are important, there are at least 3 steps with wider help to survivors that Ukraine can and should do at the moment. First, it's the introduction of the criteria for a registry of victims of atrocity crimes, so that people could have an unimpeded, quite effective procedure of nominating themselves as survivors, and that hopefully would contribute to further reparations framework once it's established. And the second 2 points were the provision of a more holistic and sustainable medical and psychological support. So it is very important that the Commission essentially reiterated what was lacking and what survivors, even before the full-scale invasion, said they needed the most, not just one at a time help, because there were certain initiatives. There was, for instance, a one at a time compensation of at about 3,000 euros for victims of unlawful detention who were captured for their pro-Ukrainian position. But first, this was still a largely bureaucratic program, not very easy to avail of. Second, it concerned only the survivors who were unlawfully detained for their pro-Ukrainian position, but there could also be the people who were captured, just for bad luck, or for trying to make them, for instance, share their property or pay to get back to freedom. So that system was first not holistic, and second, it was it wasn't enough in terms of the sustainability. So the UN Commission quite mirrored the needs of survivors and I'm sure Mariana will comment on how the Ukrainian government now really takes that into account. And with the register of the Council of Europe, the register of damage, it is an important development. It will be based in The Hague, and it is essentially the first step to hopefully further move the policy regarding the freezing and repurposing of Russia's assets. But with respect to the role of this Council of Europe's registry for reparations to individual victims of atrocity crimes, I have several concerns and I will voice them. First, it seems that the registry deals more with the consequences of Russia's responsibility as a state, rather than with the responsibility of its direct perpetrators and commanders arising from the alleged war crimes, crimes against humanity, or genocide that they committed. Second, most alarmingly, the registry applies to damage which was caused starting from February 2022. So essentially to the events that cover the full-scale invasion, which leaves the survivors of the initial 8 years of the war fully uncovered by this initiative. Also, the registry doesn't seem to provide for interim urgent reparations or the avenue for interim urgent reparations, and indeed the urgent medical, psychological, gynecological support. It's the form of these urgent interim reparations which the survivors need most of all. So at least these three areas seem to be either not covered by the registry, or there seem to be an important lacuna, especially with respect to the timing, to the temporal framework that starts for this particular registry from February 2022. And finally, to sum it up and leave more time for the discussion, I would want to say how reparations might arise in the context of the prosecution of Russia's aggression. Before the full-scale invasion, before this whole new debate about prosecuting the crime of aggression, there have been a couple of academic publications by Professor Shane Darcy, by Erin Fourbier, about individuals being qualified as victims of the crime of aggression. And this is very important because understandably, under the international criminal law framework, before the International Criminal Court, persons are recognized as victims of war crimes, crimes against humanity, and genocide. And aggression is listed in the same list of crimes. So there is an emerging discussion that individual people and not states, as it was with Nuremberg, should be considered victims for the purposes of the crime of aggression. And it's interesting to see how the future model of the international, special, or hybrid internationalized tribunal to prosecute Russia's aggression will deal with this issue. Because it's not just about the detailed and nuanced consideration of the victimhood and allowing the people to present their trauma from the war. It's also about very practical issues of reparations and whether the recognition of individuals as victims of the crimes of the crime of Russia's aggression would entail certain impact for their right to reparations under the framework of a potential tribunal. So this is just an interesting question, I think, practically, scholarly, but more importantly, humanly for us to ponder upon. Thank you very much.
Thank you very much, Katerina. Felix? Yeah, you want me to start? Okay.
Thank you very much, Jean-Pierre, for the invitation. Very happy to be here at VCOL, sharing the panel with this fantastic lineup of experts in the Ukraine and Russia context and on post-conflict justice. So before starting my presentation, I would like to outline my main points and explain where my intervention is coming from, because I'm going to be a bit skeptical about the suitability of adopting a transitional justice framework right now in Ukraine, and to use this framework to underpin a reparation policy. I do believe, of course, that some form of redress is needed right now to tackle, to some extent, the harm that the victims of the war are facing, especially those victims of the Russian aggression. In principle, I should think that this should be a framework of collective reparations with individual reparations for certain cases. But however, I also see that the mainstream understanding of transitional justice may not provide an adequate rationale to support these reparation efforts that we need to implement. And when I speak about a mainstream approach to transitional justice, here I am speaking about the framework that was developed first by the International Center for Transitional Justice, the ICTJ, and which has been increasingly accepted by the UN since Pablo de Grave became the first special rapporteur on the rights to truth, justice, and reparations, also when Pablo was one of the lead researchers at the ICTJ. And also, as you mentioned, he was one of the members of the International Commission of Inquiry on Ukraine. And one of the key pillars of this understanding, of this mainstream understanding of transitional justice, is that reparations needs to go hand in hand with acknowledgement of wrongdoing. Reparations, according to de Grave, in his capacity as a special rapporteur and in many publications that preceded this appointment, he heavily criticized that reparations should be based on the basis of solidarity, because underpinning reparations on the basis of solidarity would undermine accountability. And actually, in the report that you mentioned, reparations are also considered a form of accountability. So reparations without acknowledgement of responsibility would be considered an oxymoron, like simple benefits, which are not radically different from those provided by a car insurance. And this was the position undertaken by de Grave in some of the reports that he submitted before the UN Human Rights Council when defining the main characteristics of transitional justice. And the key issue here is that since in the present context, Ukraine will not take, of course, responsibilities for the abuses that result from the invasion of Russia, then reparations will not work as a means to bring about accountability for the abuses perpetrated by the Russian invasion. And they would be considered rather somehow as simple benefits. And this, I think I'm going to argue later, is going to pose certain challenges to define in the end who is going to receive reparations. So this is a bit the main argument that I would like to defend. I like a lot how the event was organized, first with Roman's session on context, because context is crucial for transitional justice, and the ICTJ and the Grave themselves, they have emphasized the importance of taking into account context in order to prevent transitional justice from becoming a one-size-fits-all formula that may be applied in context where perhaps it may not be needed. So here, a bit of history, I think, is in order. We know that the field of transitional justice emerged to address violations by states regarding their own citizens in the context of transition from dictatorships to democracy, especially in the south of South America, emblematically in the cases of Chile and Argentina, but now it's applied mainly in post-conflict settings. And we know that there are huge differences between Chile and Colombia. I come from Colombia, so some of the reflections are inspired from my personal experience there. So in post-conflict settings, we have a considerably higher number of victims. We have less capacity than Chile and Argentina had, for instance, to deal with previous wrongdoing. We also have widespread poverty and other socioeconomic shortcomings, and a plurality of actors responsible for the violation. So it's not only the repressive state that is at stake here, together with its proxy militias, but also we have rebels that were challenging the central state, as well as often the civil population that are pitted against each other. So in this context, the mainstream approach to transitional justice, they have highlighted the importance of undertaking a functional analysis about what are the expected results that we would like to pursue with the implementation of transitional justice, and the likelihood of achieving actually these results when we apply these measures. And this is to avoid implementing, as I mentioned before, one-size-fits-all formulas that have little chance of successful implementation. And this Lars Waldorf in Essex, Roger Duthie, which in the ICTJ, and Pablo de Grave, we have emphasized the importance of this functional analysis to determine whether the measures we're implementing are useful for the goals that we would like to pursue. So following this analysis, for instance, this that is still called mainstream and in no pejorative way at all approach to transitional justice, they have argued against, for instance, guaranteeing economic and social rights as a means of redress. And this is quite important because in in your exposition, you mentioned that economic and social rights like housing, property, and medical support are crucial for victims, one of the most important preferences. But the economic and social rights, they have traditionally been excluded from this traditional approach for two reasons. First, because they shouldn't, according to them, be understood as a means of reparation, because economic and social rights are rights that people enjoy in their quality as citizens instead of victims, so we shouldn't conflate them. And also, economic and social rights, they don't bring about accountability, because authorities are providing economic and social rights on the basis of their duties towards the vulnerable population instead of recognizing wrongdoing. So this is just an example of how a functional analysis would have led to exclude certain nature of victims from the perspective of the transitional justice canon as it has developed right now. So in the current Ukrainian and Russian context, I think that there are many new characteristics that also would require such a functional analysis. So in contrast to most previous cases, perhaps Colombia the exception, we're still facing an ongoing conflict and we cannot envisage when or how it will end. So for instance, we've heard recently that Macron, in a very not very popular remark, he suggested that perhaps compromise was better than trying to bring Putin to justice for the crime of aggression. And also we have heard that certain political forces within countries, they also would prefer certain forms of compromise, which may include allowing Russia to maintain control over parts of the territory legally acquired. So if any of this sort of compromise agreements is reached, then we wouldn't have the recognition. Russia, of course, wouldn't recognize at all recognition, wouldn't recognize wrongdoing, and this would underpin any attempt of reparations to address this issue. Also, in contrast with most previous cases, this is the first time that transitional justice, understood as a separate and distinct field of study, would apply to an armed conflict of an international character. So as a result of these factors, very likely transitional justice would be implemented mainly from a one-sided perspective. It would be implemented from the Ukrainian government with certain support of the international community for Ukrainians in the areas where they have control. And of course, Russia with difficulty will engage in such policies because if I remember in one of the blog posts that you wrote that I loved so much and that you shared with us recently, Russia is very hostile towards these transitional justice attempts because it considers they are a betrayal of the Minsk agreements. So what consequences would follow from this from the perspective of reparations? Reparations for violations perpetrated by Russian forces then would lack acknowledgement of wrongdoing, undermining a bit the whole transitional justice conceptual structure, because as I mentioned before, from this perspective, reparations without acknowledging of wrongdoing, they are just simple benefits. And as you mentioned before, regarding the case law of the European Court of Human Rights, it's expected that Russia will, at least in theory, remain with the responsibility to repair some of the wrongdoing that has taken place in the east of the region. So, but very likely, because of political considerations, this may not happen. So we will have a difficulty in bringing about reparations, while at the same time acknowledging wrongdoing. We have also the situation of reparations for violations perpetrated by Ukrainian forces, which are much more limited than those perpetrated by Russia, according to the report of the Grave and the other members. But there is a political, or perhaps, objection to this, and perhaps I think this is perhaps the reason why the transitional justice program that was discussed and that was endorsed by Zelensky at the beginning, he later perhaps stepped back. And this is that perhaps from a political perspective and from a political narrative, people wouldn't like the idea that Ukraine is repairing the harm perpetrated by the invader, while only Ukraine and not Russia, the invader, is being held accountable for serious abuses. In this case, for instance, before the European Court of Human Rights, because Russia won't be held accountable for abuses there because they were expelled from the Council of Europe. So in order to address these problems, perhaps we would like to separate reparations from accountability. And in that sense, we may avoid some of the difficulties that arise when transitional justice try to keep these two concepts together. But if this is the case, then we may have a some difficulties trying to identify who needs to be repaired and why. We know that according to the principles on the right of victims to a remedy for violations of, for gross violations of international human rights law and serious violations of IHL, that only victims of these violations are should be entitled to the set of measures of transitional justice. But when we think about the situation of internally displaced people, for instance, which is one of the most serious humanitarian concerns right now, we would have that following this criteria, only certain IDPs would be repaired, because only under certain circumstances, internal displacement is the result of such gross violations of international human rights law and serious violations of international humanitarian law. So for instance, in the case that you were mentioning before, that some people were like somehow forced to go back to the Russian territory, which is under control, in order to accept reparations and to have the status as IDPs. Would these IDPs, the situation of them would fall as a serious, the act triggering the displacement would be a gross violations of international human rights law or a serious violation of international humanitarian law? It's difficult to tell. It's very interesting what you mentioned, that perhaps they are victims of the crime of aggression as such, but these are concepts that have not been fully developed. So in the absence of many IDPs not being directly the result, not having been removed because of any of these serious violations, we would have a differential treatment between them, in which only, I don't know, perhaps displaced people forcibly displaced in violations of international criminal law would receive reparation, while others, they may not. And I think that this is a situation that may be a bit complicated in terms of equality, also if they are facing similar shortcomings, and if the purpose of reparations at this stage is not bringing about accountability, because we are not here dealing with the obligation of Russia to redress the violations for which, of Ukraine to redress the violations for which Ukraine itself is responsible. So in the case of IDPs, I consider that perhaps a collective approach to reparation could be better suited, taking into account the very different reasons why people are displaced. But perhaps I do consider that in cases of sexual violence and other similar episodes, perhaps an individual approach to reparations that takes into account all these economic and social concerns is also in order. But then here again, we would fight a bit with the canon of transitional justice that tries to keep separated economic and social rights for separation. So the bottom line of these considerations is that, of course, victims should be the top priority in the situations in political terms, resource-wise, but sometimes we may consider whether transitional justice, as it has been developed right now, is the best field to address these concerns, or whether we should try to make a functional analysis in which we can determine what other avenues we can use in order to bring about, even if it is a modest doses of reparations and acknowledgement of wrongdoing in those that were affected by violence. So in this, to finalize this intervention, I would like to ask both of you, what other contextual factors of this armed conflict of an international character, which is ongoing, we should consider in order to try to determine the suitability of introducing transitional justice policies right now, or perhaps later when the hostilities have finished. As the Grave himself, I think he also recommended in the report that he presented as part of the Commission of Inquiry. That was 15 minutes and 4 seconds.
Is dealing with temperature. Serena and Ron, do you want to wait for and listen to my response first, and then discuss them? Whether you would rather reply to Felix or me?
Waiting for so long. Sorry, but
yeah, let's go from here. And then we that would also be the purpose of time to so Mariana, thank you very much for bearing with us, and we will need to unmute yourself, and then
Thank you very much. Can you hear me well?
Thank you very much. Can you hear me well?
I would like to know if you can hear me. Hello?
Yeah.
I'm not hearing you back. Yes, good, great. Everyone online can hear me. I'm hoping in the room also. Just, I'm getting a bit.
Yes, we can hear you.
Oh, wonderful. That's great. I was having connection issues and I missed all of the last speaker, but I've managed to work around it with a new device. So I'm glad to be back. And thank you so much for inviting Global Survivors Fund to be part of this panel. Essentially, we would like to just also bring in a little bit the work that the Global Survivors Fund, perhaps some of you don't know about the Global Survivors Fund, and also really honing in on conflict-related sexual violence and the right to reparation in Ukraine for that, and what we've been doing, also working with Katarina, who is on the panel as well. So essentially, I just wanted to share a little bit our experience on conflict-related sexual violence and just tell you a bit about the Global Survivors Fund. This is an organization that was established actually recently during COVID. The founders are two Nobel Peace Prize winners of their on rape as a weapon of war, Denis Mukwege and Nadia Murad, the Yazidi survivor. And the essence and the genesis really of creating this organization came from survivors and the need to prioritize reparation for conflict-related sexual violence. And this is exactly what we're trying to do in Ukraine as well, because we always see that reparation is always an afterthought, needs a lot of unpacking, and is quite a technical concept for most policymakers, not one that they're used to either. In Ukraine, there's the additional difficulty, as raised by other speakers, of this idea that reparation should really come from the Russian state, and is an interstate issue, as a kind of public international law issue, as opposed to also being now an individual right under the human rights framework. So this also requires some unpacking. But in essence, the main point that I really want to just to share is the issue around urgency. So why are we working on this right now? Some people would think reparation should come at the end, once the conflict is over, etc. We know that reparation for survivors of conflict-related sexual violence is quite particular in relation to other violations, because it comes with stigma and a sense of dehumanization that means that recovery is much more difficult. And that shame and guilt that comes with the types of violation means that sometimes accessing other services and recovery paths can be more difficult. So when time elapses, the harms just become compounded over time. So the work of the Global Survivors Fund, in Ukraine, really, we are focusing on the establishment of an urgent interim reparation program for survivors. And we have been working with a number of actors on the ground, and in particular, a big event that we had recently in Geneva brought members of the government from a range of ministries to sit around a table and work on a draft law for urgent interim reparation. While we had a model draft, one of the participants also was representing a member of parliament who had also a draft. So the focus has become around this draft from the lady, Madame Berdina, she's called, the member of parliament. And her law on urgent interim reparation is really taking momentum now, and it looks like it may be presented in Parliament in September, and we're hoping to support the implementation of that. So perhaps that's just a little bit about the work that we're doing, and maybe also to explain that there is now several tracks on reparation going on in government. There is, on the one hand, this urgent interim reparation for conflict-related sexual violence that is being centered around the Ministry of Social Policy. There is also a slightly slower track on comprehensive reparation, which will be for all victims of violations. And at the same time, there is the international register for property and damage. So then these three instruments are now working together. So it's interesting to see that in the draft law for the urgent interim ones, it's already being stipulated that this law will be cancelled when a comprehensive reparation program takes effect, and it will incorporate the survivors and victims who are registered under the interim urgent one will be subsumed into a national wider one. So that's essentially where things stand. Also, the way we understand it is that the laws in Ukraine normally are quite a framework. They're like a kind of structure and often get filled in by bylaws, which then will provide much more of the detail. So our understanding is that if this draft law goes to Parliament in September, we still will be looking at the two bylaws maybe that need to be adopted, one on the architecture and the implementation and what that will look like in terms of which ministry will be in charge, etc. And then another bylaw is being talked about in regard to procedure and eligibility, how victims will actually apply, what their eligibility criteria will be, etc., to actually claim the individual reparation. So that's a little bit about where things stand on our work. I would be keen to hear from Katarina also her views on the architecture and the interplay between the urgent interim, the comprehensive national, and the international register, and her views on that. And in particular, knowing the context more in Ukraine, how, and also having worked with survivors, what the most ideal architecture would be for implementation of a reparation program, in her view. I don't know whether I need to fill fully the 15 minutes required, or whether it's just to kind of get the conversation going on reparation. But that was one of the questions I wanted to ask Katarina.
Okay, thank you very much, Mariana. And no, absolutely no need to fill 15 minutes. I think your question will get the discussion going very well. Roman, you seemed very keen to go quickly, so I'll hand over to you and then over to Katerina.
Thank you very much. I just have a comment on Felix's wonderful intervention, I in particular, I like very much your clearly distinguished points on reparations and accountability. Of course, the question what you raised, and you put on the question the issue of solidarity, I think on the Russian side, yes, in terms of reparations in particular.
That if Ukraine implements the reparation programs, it would be doing it perhaps on the grounds of solidarity instead of its own responsibility for violations, which resulted from the intervention from
So here question comes actually in how and in what legal documents this issue could be fixed and solved, especially with regard to distinguish reparations and accountability. I suggest, and it could be criticized, that it's very important. There are two issues which could play a crucial role. First, the actual peace deal, and the peace deal which is going to come certainly must and will have a section, and I guess on reparations. Why? Because following the context what we have just described, it's extremely both sides of the war do not recognize any damage caused. They accuse each other in actual facts and causes of the damage. Especially, for example, we can see the recent blowing of the Kakhovka Dam, which caused extremely far-reaching individual and collective and environmental damage, not only on the Ukrainian territory, but international territory, Danube International River Basin and the Black Sea region. Both sides accuse each other, and it's actually the actual fact could be reached. It's very difficult to actually seek evidence and to prove who did the actual cause damage on the dam. So I think, and also there is another issue related, of course, as you correctly noted, that Russia also might and would certainly seek during the peace deal negotiations its right for reparations for damage caused on the Russian territory. But of course, it has been done as we follow the narrative not by Ukraine, but by Russian volunteer groups penetrating the border and causing the damage. So basically, taking into account all these factual complications of the case, I think the actual peace deal is going to be the key document to define the issue of reparations on both sides, because they must come into agreement how to deal with the factual facts and how to actually whether to apply the issue of solidarity or I don't know, what other approach you could do. Then accountability. Again, I think it could be subject of consideration of the tribunal to be established. There is a debate, as you know, what kind of judicial review is going to take place. There are two approaches. International judiciary is not feasible due to the limits on recognizing the aggression, as we know. So Ukrainian jurisdiction is also under question. It was proposed by the EU, but the Ukrainian government doesn't want to accept it for some reasons. So the only hope is to set up a separate tribunal. So I think this tribunal is going to actually consider taking possibly some facts proved by investigations or evidence to solve the issue of accountability. So basically, I think these two issues are very important: peace deal and the forthcoming international tribunal, which are going to define these two issues. Thank you. So maybe you can also add something. Yeah. And okay.
Katrina,
yeah.
how about you?
Thank you very much, dear colleagues, for amazing, very intellectually challenging interventions. And I'll respond first to Felix's with 3 points. First, the point about an interstate armed conflict, and this is not the usual, to say the least, the context for transitional justice. I think it's both the strength and the weakness, because you asked us to comment on the context, right? The strength is that I think because when we speak about TJ as a transition from a repressive regime, Ukraine's transition happened before the beginning of the full-scale war. Ukraine's transition had solidified in 2013 and 2014, when the people hit the street and said that they will not tolerate not just the suspension of the EU integration, they will not tolerate the violence from the law enforcement towards the citizens. And this is how the people of Ukraine forced the ex-president from the country. And this is why essentially Russia invaded, because they felt that they were losing it to the country that had really changed. So I think because there is a concern that the transition has not happened, therefore the conversation about TJ should not happen in Ukraine. I think the transition has happened. There's a unique combination of the standing government, because previously in other contexts, the governments also went in exile, right? And Ukraine's government did not leave Kyiv. The president didn't leave Kyiv last year. The civil society is uniquely strong. Having had the complicated but still solid experience in documenting conflict-related crimes, in engaging with survivors, in getting more trust from survivors than oftentimes the investigators and prosecutors do, I think again it's the unique strong combination. And we also increasingly have the organizations of survivors, and the Global Survivors Fund works domestically in Ukraine also with STEMA Network Ukraine. This is the organization of people who have been through conflict-related sexual violence and who speak about their experience and who lobby not just accountability, but reparations. So what I'm just saying, I think despite all the challenges, Ukraine has the unique opportunity of having the strong unity of the government, the civil society, and the survivors who have a strong vision of how they want to engage with Russia, and that they want this holistic TJ policy. Now that it may not be completely fully implemented at this stage, I think it's also a very reasonable point but that practically, because we have essentially the elements of TJ, different proceedings, the initiatives you've heard about, the draft laws from Mariana, the draft laws on urgent interim reparations being proposed, I think there is also a rational argument that we want to unite these initiatives under a holistic framework, to harmonize them, to make sure that the money that Ukraine also gets, right, that they're being used in a very effective manner, that again, that this system of reckoning, as much as it's possible at the moment of when the conflict is still ongoing, that it's as effective as possible. So therefore, this is my argument why still the context says that we can deal with it. And my second argument about the context is that a strong and effective transformation in Ukraine will be a push and a model for the Russian and Belarusian civil societies to catalyze TJ in their countries, because it's up to the civic leaders of Russia and Belarus to then hopefully finalize the transformation within their countries. And I wish that they could happen earlier. I still think that Ukraine will be able to complete its transformation before Belarus and Russia, but hopefully it will be a success story for the region, which hasn't dealt with traumatic Soviet past and which hasn't really reckoned currently with their complicity in the aggression against Ukraine, and how they want individually, as the free and democratic one day Russia and Belarus be. So I think the successful transition in Ukraine now could be a push and an inspiration for Belarusian and Russian civil society leaders. Now, as regards the reparations for the damage caused by the Ukrainian side, I fully support it. I agree with you that, all the viable evidence, though, as supported by the report co-authored by Pablo de Greve, as stated by the UN High Commissioner for Human Rights, that it appears that the vast majority of crimes is being perpetrated by Russia. Therefore, we're not being one-dimensional in how we discuss this at the moment. But of course, if there is still a small portion of crimes perpetrated by Ukrainian side, it should be prosecuted. There have been prosecutions of the Tornado Battalion in relation to sexual violence at the beginning of the war. It's always the sensitive issue, but I'm very happy to hear, at least from the leading human rights NGOs that document the crimes, as well as from the prosecutors of Ukraine, that they will be and are looking at the crimes perpetrated by all sides. So it will be challenging, but hopefully it will stand, because it's about the centrality of the roles of survivors and their interests. And as regards the economic and social rights, and that's not necessarily how the reparations should go, I would just specify that the survivors would say that for them, the most important form of reparation first would be Russia's accountability, yes, and also knowing eventually that finally the reparations for them, be that this medical support, a housing, that eventually still it will be the Russian funds that will go and fund it. So I would say it's very complicated. On the one hand, we should be practical and speak about the urgent needs of the people and how we can and should help them now. On the other hand, they would always say that it should come parallel with the recognition that this is the damage, independent, factual, and legal recognition that this is the damage caused by Russia. But as of now, it's still covered by Ukraine or by international partners, because Russia's funds are not reachable. So perhaps I'm not here being very scholarly, and I speak more from the perspective of the people, because nothing has been more transformative for me as a professional than the work with these victims who have been through this horrific experience, and then they want to speak about it, they want to contribute to policy making, and they want to really make it holistic and sensitive and effective. So here I would still go with this socioeconomic dimension, of course, recognizing, that this is not that full accountability the way we'd want it. And with respect to Mariana's question, thank you very much about this multiplicity of urgent interim reparations, comprehensive national reparations, and this new registry and international initiative, and how they interplay. I think this is a big issue, and with the registry, as I said, My main concern is that it seems to deal only with the damage caused after the full-scale invasion, and it doesn't really touch upon perhaps certain further documents will touch upon whether it could potentially cover different types of reparations, because what we need is not, of course, to build upon the holistic picture and these final comprehensive reparations, but what I support fully from the human perspective is ensuring these first steps. So the initiative for the urgent interim reparations in Ukraine domestically, I think, is crucial. What I'm concerned as of now is that this initiative seems to focus only on victims of sexual violence, again, because it's the constellation of effort, and this victim group and their organization has been particularly advocated and representative. So I think the current challenge for me would be not the interplay of these three instruments, but how we ensure urgent interim reparations for victims of all atrocity crimes in Ukraine. And then, of course, we speak about a more holistic framework. Although I don't know whether I answered your question fully, Marianne. Would be interested to hear.
Perfect. So we will come back to Felix and Mariana. We do have a question that came in from one of the online participants, but Felix and Mariana, do you want to reply back, and then we'll turn to Veronica's question?
Thank you very much for your replies. Yeah, there is no UN document denying the importance of solidarity as a foundation for reparations. This is more a discussion that has been tried to introduce at the UN level in, if I'm not wrong, in the second or third report that Pablo de Greve wrote in his capacity as a special rapporteur. There he emphasized that reparations should be in themselves be considered a form of accountability. And in that sense, he very harshly criticized the idea of underpinning reparations on solidarity. And that's I think that comes from the Colombian context, because Pablo de Greve was very active also in Colombia when we were having the discussions. It has, I think, political dimensions in Colombia, but I don't think that it should be a problem internationally speaking, especially when we have a context like this, in which we have two different entities, in which it's very likely that we're going to have difficulties in establishing accountability, as you mentioned, and this perhaps may only be possible after we have a peace agreement, or after some sort of international authority would consider legitimate from both perspectives, establishing that this is how wrongdoing should be distributed. And the point of highlighting this is, I am not a fan of this mainstream approach to transitional justice. I don't think that solidarity in itself is wrong as a weak basis to underpin reparations. There are also many other ways to underpin reparations in human rights law, such as the positive duties of the state towards its population, which I think that they can perfectly see the responsibility towards victims of sexual violence and to make it as a priority. My concern is rather that the field that have developed has adopted a position which perhaps doesn't give the flexibility to address the reparation needs of victims in Ukraine that we're looking for right now, including the interim measures that we were mentioning before, because de Greve himself, he was clear that reparations, properly speaking, should be wait until the conduct of hostilities has been done, which I don't think is necessarily the case. I think in Colombia, reparations were also implemented in the middle of the conflict, and they were useful in many ways, but this would be a framework which is not necessarily the prevailing transitional justice framework that we're having today. And of course, Russian funds would support the model, and I think that would also bring in certain doses of accountability, because it would be Russia who would be paying for the damage they caused with the invasion, and that makes sense. But I find that a bit sometimes it's too strict, this approach of putting together responsibility, the accountability, and reparations, because Russia wouldn't be recognizing the wrongdoing, even though we use their money to support and to fund the reparations for Ukraine. Russia wouldn't recognize wrongdoing. And if this recognition of wrongdoing by the wrongdoer that the current framework considers is indispensable in order to have a proper reparation policy. And I think that we don't need to go that far in order to start implementing measures of the ones that you suggested.
Thank you very much. Mariana?
Thank you. Yeah, I'd like to also just contribute to this exchange on the individual right to reparation under international human rights law, which is one that was crystallized really within the UN Basic Principles on Human Rights from 2005, which at the time I think we could all agree were really an emerging norm in some respects, but in other respects really reflected fully accepted standards. But in the meantime, there has been a growing body of implementation of individual human rights as an administrative right, in terms of mass violations done through national administrative reparation programs from so many countries that I think by now we really can talk about an obligation of states on the right to reparation, which when we look at the basic principles and the precedents come from case law, from the Inter-American Court, from many sources, the right to reparation really is, first of all, irrespective of who the perpetrator is. So you don't need to identify a perpetrator to be a victim and for those rights then to flow. And at the same time, those rights flow from the moment of victimization. So there isn't a need either to wait until the conflict is over. So those really for us are important cornerstones to our approach, and also the understanding that really also in particular for conflict-related sexual violence, I hear you, Katarina, saying that really we should be looking at urgent interim reparation for all categories. And I think that the comprehensive reparation program will follow. And in a way, we see this one as a pilot really and to sort of pave the way. I think that the difficulty with conflict-related sexual violence is that because of the stigma and the shame, people don't come forward. So you need to start sensitizing people about their rights well before, in order to ensure that then people will come forward. And so we're hoping that if we have a head start on this, we will start to break down the stigma, people will start to come forward and feel comfortable, and the conversation and the silence around these, and the denial also around this violence will be broken down to create a more of an enabling environment for reparation to happen. So I think one thing shouldn't exclude the other, but anyway, I just wanted to kind of come in on the the individual right and the sense of urgency, and that this right really doesn't depend on who the perpetrator is. Having said that, this then raises the question of who finances it. So should it be the international community? Should it come through this international register, etc.? Donors, governments from other countries may be willing to fund a reparations program. So yeah, that's my few cents from here, from the screen. Thank you.
Thank you very much, Mariana. I'm gonna read Veronica's question, and I hope I can do it justice. Veronica says, good morning, everyone. First of all, thank you very much for all the insightful and interesting presentations on such a timely topic. I have some questions about what are your thoughts and perspectives on the functioning of the Council of Europe Registry of Damages. I was first wondering what should be, in your opinion, the relation between the submissions to the register and complaints or proceedings conducted by other international bodies and courts involving the issue of reparations related to the Russian aggression. Example, the European Court of Human Rights, amongst others, but also the ICC proceedings, future possible developments. Mainly with a view of avoiding confusion and possible duplication of complaints and awards, even if we know that Russia is not fulfilling any European Court of Human Rights judgment since, at the very least, January the 1st, 2023. Later on, by using the expression information claims on damages, loss and injury, the Council of Europe documents seem to suggest that the submissions to the registry will contain not only evidence, but also claims. Nonetheless, I'm struggling, and for this, I would be interested in hearing your thoughts in identifying what should be the legal basis for those claims, insofar as they can involve, as we know, questions of European Convention on Human Rights applications, but also international humanitarian law. And apologies for the long question. Veronica, I saw that you came online, so if you want to clarify anything, and if I didn't do the question justice, please do feel free to add to it.
Thank you. Actually, I have nothing to clarify. I think that I spent way many words on this, so I am very curious to hear your thoughts on these questions. Thanks.
Who would like to take this question?
I can start. Just thank you very much. Thank you very much for the question, which is a very complicated one. I think looking at at least messages from the Ukrainian government, it looked that this registry was like the principal registry so far that the Ukrainian government at least regards as such, and I think this is important. And I think it would be important to have the holistic, to attempt to try the holistic vision of the damage submitted to such a registry, because there are the challenges with the ICC proceedings, there are the challenges with the European Court of Human Rights proceedings, the timing, what types of cases will be prioritized. So while I understand the concern that certain individuals or might receive individual or collective reparations under the ICC framework, right, it not necessarily will show us the holistic picture, which at least this registry seems to attempt to show. The concerns just that I have with it as of now are the temporal concern, again, that it covers the damage caused since the full-scale invasion. Also, perhaps I should read more and better the text, but it did seem to me that it's still more about the state responsibility, and then the question again more arises how that interplays with the damage coming from individual criminal acts perpetrated by direct perpetrators and arising out of common responsibility. And also, yes, how that registry, if at all, will be relevant for the urgent interim reparations, or it's something that aims to show like this just bigger holistic picture and then eventually will impact this final hopefully comprehensive reparations framework, for instance, mentioned by Roman, under the potential peace agreement. These are the questions that still stay with me. Thank you.
Maybe I can, well, it's, I'm not a particular expert on this issue, I would like to warn, but I would like to share some of my thoughts. First, it's in general, is the idea of having this registry, and it's already in place. Is it in place already? It's an excellent idea. Certainly, it's a good start with. Furthermore, the Ukrainian government has already launched its own registry. So there is a system in Ukraine when all Ukrainian nationals can submit their evidence and claims for compensation online via a special app called DIA. So the Ukrainian government has already started collecting certain information and evidence, which possibly can be used for this further registry under the Council of Europe. How it could be done technically, I think it's a quite solvable matter. Certainly, claims could come from physical, natural persons and companies, and could relate to different types of damages to property, personal damage, or damage to health, or caused by environmental emergencies and so on. So technically it also could work. My, of course, question, what I think concerns everyone, who is going to pay and how this compensation, how these reparations could be compensated. Already today we have a primary estimate of the damage caused to Ukraine in general. It's about 600 billions. It's a lot of money. And of course, it poses a very big question, who is going to cover this cost? Of course, international community could accumulate some money, and the European Union has already created the solidarity fund for Ukraine. But of course, in any case, it wouldn't be able to cover all the cost of the damage. How the Russian Federation could be accountable for this, and how it could certainly contribute to cover the cost of this damage. First, there are some interesting issues which we already at this stage should take into account. Peace deal, certainly it's a starting point, but there is a question, who is going to be sitting at the peace deal table in future? Certainly in case of a military defeat or serious military losses, there is a high probability of the change of regime in Russia, or possibly change of its territory. And of course, according to the rule of succession, next government is going to be liable, but nevertheless, it may complicate very much the issue of the peace deal in a long-term perspective. So it's one issue. Second, humanitarian nature of, well, how to describe it, nature of the reparation. We know we have two interesting historic examples: reparations after World War II and World War I. As it looks, of course, Germany and Japan, they didn't pay reparation to full. It was a very intricate agreement. Basically, in case of Germany, there was only a peace conference which took place, but there was no agreement in general to decide on the scope of reparation. So basically, Germany only didn't pay reparations as such immediately after World War II. Only it lost some properties which were taken by the Allies. And we all know and remember the historic example after World War I, when Germany had to pay definite exact sum of the reparations, and we know what happened later on. So there is a discussion what kind of how reparations after the end of the war in the peace deal are going to take shape and form. And I think it could be very interesting historical experiment, and already time to speculate and talk about it. So there is a big question whether the Russian economy, it's nice, but I'm not sure if it's going to cover immediate cost of $600 or $800 billion or euros straight away after the conflict. Possibly there's going to be room for some kind of not one-time straight reparation, but long-term going reparations through, for example, either selling natural resources under special rate or without any rate to Ukraine for a certain period of time, or having schemes similar to like it were applied vis-a-vis Iraq or Iran. There was a very interesting arrangement called oil in exchange for food. I think it was applied for Iraq, when Iraq was selling certain, or possibly Iran, I could be mistaken, certain natural resources, and only percentage of a price was coming back to this country. So it opens for us the whole plethora of different forms how to ensure reparations to come after the peace deal. So I think it's actually worth to discuss in future how it's going to take place. Thank you. Yeah.
Thank you very much. We are running out of time. Originally, this event was planned to be an hour and a half, and I have a habit of having events run over. So I planned it for 2 hours, so that, and turns out we're almost at the 2 hours. So what I would suggest is we go in reverse orders of the original speakers in case anyone has any last comments that they would like to make. But before I do that, is there anyone else who is with us online or in person who would like to ask any questions or make any comments?
I would say this was really so
you need to use the mic.
Oh, sorry. Thank you. I just wanted to say this was really informative, and thank you so much for sharing your insights with us, especially in regard to, I thought the conversation about the distinction between accountability and reparations was really interesting. So yeah, really, really appreciate it.
Thank you very much. Anyone else? Of course.
Just as briefly as possible, I'm wondering how helpful you see the European Court of Human Rights being in this picture, or whether it really falls out of the picture because of Russian withdrawal. And yeah, is there any hope in that sphere for playing a part in the reparations here?
Hi. Yeah, I think that the court, I think that today, this year or the years before, Ukraine has been the country with more claims before the European Court. There are reasons of administration of justice which explain most of the claims, but issues related with the use of force in the eastern regions of Ukraine have already been dealt with by the court, and in the future we can assume that this will continue to be the same situation. So the court may order measures of just satisfaction for abuses perpetrated by Ukraine forces in the conduction of hostilities. The amount of cases, the number of cases, I don't know if it's going to be high or not, because the court has been trying to prevent from becoming a court which deals with daily episodes of the use of force. But we would have a situation which is a bit tricky, because the state that upholds the ECHR principles is going to be held accountable, and reparations are going to be ordered for the conduction of hostilities, while the other country that initiated the aggression and has left the European of Europe is not going to be required to provide reparation under that framework. It's going to be one-sided.
Just if I may add, I think the ECHR's pronouncement was important, like it was from a Dutch court, on actually Russia having effective control over eastern Ukraine and establishing the date. And it's generally, when we hear about this rapid response to Russia's war against Ukraine, usually the Ukrainian lawyers would say, no, the response has not been really rapid. For 8 years, nobody has really noticed or acted upon the mounting violations there. And of course, there was always very vague political wording about Russia's presence in eastern Ukraine. So I would say, despite the whole human centricity, I think the principal impact so far with the ECHR has been to really say that Russia has had the effective control over and the presence in eastern Ukraine since spring 2014.
Thank you very much. And now we are really pressing on time. So I will go to Mariana if you want to answer the latest question, but also any final comments that you wanted to make.
No, thanks. That's great. I think the others have said, maybe just to reiterate the two different areas of law that we're talking about here, really. One is a public international law, interstate reparation, you know, following examples, you know, post Germany, etc. Also, but there are other examples that are normally adjudicated in the International Court of Justice, like DRC versus Uganda, DRC versus Rwanda, where there are also awards for interstate reparation, which is one thing. But then also, just to reiterate, we have the human rights framework where we have individual reparation as well. And I think that's what the frame of today's discussion was around, or individual right to reparation and that. So yeah, I agree on the issue around the European Court of Human Rights. Again, because we're talking about a human rights framework, the state that is going to then be held accountable is Ukraine if a case is being brought for human rights violations, not Russia. So that you can't cross over to another country in relation into those violations. So that's why when I was speaking earlier, I was trying to emphasize that the individual right to reparation, the obligation to repair, of course, is the wrongdoer, but it's also the state. So then the state of Ukraine has also got an obligation to make that repair, regardless of who the perpetrator is. But of course, it will need the support of the international community to be able to finance the reparation, and how the financing will come in, whether there will be an international fund, whether it will come in through the international register or other mechanisms. And there's a lot of goodwill and interest in terms of the funding and the financing of reparation. So I think that we need to watch this space. Thank you so much for such a great panel and discussion. Thank you.
Thank you, Mariana. Felix, would you like to add anything?
No, thank you very much.
Excellent. Katerina?
Just a minor comment on urgent interim reparations and the connection with accountability. I think it's very important that the draft legislation that Mariana has mentioned say that victims can register without the need to be part of the criminal proceedings. And I think this approach is very important. And this is also in itself is a remedy to survivors, because we're not forcing them to go and cooperate with investigators and prosecutors who are not ready to, when they're too traumatized by their experience, but re-emphasize that their right to remedy and reparation is independent and can be started as early as possible. Thank you.
Yeah, thank you very much. And I fully agree and share views of Mariana about the complexity of this issue. It's indeed an amalgamation of international public law, private law, interstate responsibility. We are certainly entering into terra incognita of international public law related to the war in Ukraine. Key issues what we agreed today we are going to face peace deal, negotiations. We will see who is going to sit at the table and how fully this party is going to accept the responsibility. There is a big room for compromise with the static and dynamic reparations. And of course, the International Tribunal. I'm quite skeptical about the European Court of Human Rights. Yesterday, I had a talk with one of Ukrainian practitioners who's working in the field, and this person said, well, there is no very little chance to acquire to any reparations via the European Court of Human Rights, even on cases related before the Russians exit from the convention. Simply because of the accumulative principle, it accumulates and there is a queue, and basically it's for private business, it's extremely difficult. So in the International Tribunal, it looks very appealing and interesting, and certainly one of its jurisdictions, priorities will be the issue of reparations and its technique and its proportionality. And thank you very much, and it was a great discussion. Thank you, Jean-Pierre, for this wonderful forum.
That just leaves me to say thank you very much to all our speakers, Roman, Katerina, Felix, Mariana. Thank you so much for being with us. Thank you for the people who joined us in the room, people who joined us online. Thank you. We will be sending out some notes from the discussion today. But I just want to say a massive thank you to all our speakers again, as well as to the Bickel events team, Liam, who has been around, as well as Bradley and Carmel from the marketing team. So thank you very much, and we'll continue the conversation. For those who are taking our short course, the class will start in 25 minutes. Sorry, Katerina. Thank you very much, everyone. Bye.